Good afternoon, Your Honor. David Fanter on behalf of the plaintiff.
Your name?
Kier Fleming.
All right. Where are we on this case?
Ms. Fleming has a balance of $4,298.39. She indicates that she mailed the rental assistance form to the court on Wednesday.
She mailed it on Wednesday?
Yeah, I didn't know. I couldn't really hear you, but I thought you said mail it in, so I mailed it in.
Well, it needs to
Proof
be at
that
the court by
that I filled out an SIR with my tracking number and everything. I mean, an SER.
I don't have it. So.
Well, I sent it in.
Your Honor, I'll leave it up to the court what the court wants to do. I don't think she, her balance is $4,298.39. She's been on rapid rehousing with SOS paying their portion. She's never made a payment to my client. And I reached out, and from what she has said, so I reached out to SOS to see if they were going to be able to help her with the balance. What she indicated to
Anyways,
me.
Can I talk? They're not going to be able to help. They're not going to be able to help with balance.
Ma'am.
Okay, stop right here because the entire atmosphere just changed. Up until now, this looked like a fairly routine eviction hearing: unpaid rent, assistance paperwork, landlord claims, tenant explanations. Then emotions take over. The tenant interrupts, the judge responds instantly, and suddenly this isn't only about money anymore, it's about courtroom control. People underestimate this all the time. In court, how you communicate can matter almost as much as what you communicate. Judges deal with stress, excuses, and conflict every single day. So when someone starts talking over proceedings, patience disappears fast. The scary part, one emotional reaction can shift how your credibility is perceived for the rest of the hearing. And you can almost see that happening in real time here.
Let him finish and I will then hear from
I don't like
you. You want to know what? You don't try to overtalk me, because that will never happen.
That's fine.
Am I understood?
Yes.
You know what? I'm going to pass the matter. You go down, check your attitude, and then I'll call your case back up. Have a seat. Have a seat.
Man, you about to piss me off. Come on.
Keep back talking. You better take that out of here.
Whoa. The judge orders her removed from the courtroom. That's a major escalation. And notice something important. The judge isn't arguing about rent here. He's reacting to conduct. This is one of those legal moments viewers misunderstand. Courtrooms run on procedure and respect. Whether you're right or wrong on the facts, if decorum breaks down, judges may become much less receptive. Some viewers will say the judge was too harsh. Others will argue he was protecting courtroom order. But here's the bigger question. When someone is under financial pressure, unemployment, housing insecurity, and stress, should emotional reactions be treated differently? Or does everyone have to meet the same standard once they step into court?
Oh, don't give me that look. Lee, get her out of my courtroom. Get her out of my courtroom. Court will pass that matter. Court does call the case of YPF16 LLC versus Kier Turner.
Your Honor, I'll wait for it.
That just messes up my whole day. Everybody else is going to have a hard time with me now. You know, I was in a good mood, and then it's just going to take one person. It just takes one person that just messed up my whole attitude. You know? Kier Turner. That's you.
Your Honor, I filed an administrative closing on this case. I was able to verify with her bankruptcy attorney that there is a bankruptcy in both their names. Okay. And so I gave to...
and I will sign the order for administrative closing.
Great.
Got it. And YPF16 versus Christina Morgan. That matter's dismissed on plaintiff's motion. And so we only have her?
Yes.
Do I want you to go get it? Not really, but I don't want to hold up Mr. Pantera. Tell her she can come back in now. You know, people, if she don't act right, it's gonna get bad. No, hey, I'm just telling you. I'm just giving fair warning.
Would you like your coffee, sir? So we can go get it for you right now.
No, I'm good. I don't know about the rest of you, but I'm good.
We respect you, sir.
Your Honor, if you want to pass.
I'll pass it and then. No. You know what? You keep talking. I'm going to do something to you too. Court has a case of Augusta Woods versus the Geraldine Ballard.
Good afternoon. Good afternoon, Your Honor. David Santa Croce on behalf of Shelby Mink. Oh.
Okay, got it. Is she in the premises? Or?
So
YPF16 LLC versus Kier Fleming. Parties have returned. Mr. Pantera, you were in the middle of your statement, sir.
Yes, her current balance is $4,123.39. Court costs of $175 for a total of $4298.39. She's been in rapid rehousing where SOS has been paying her portion and she's supposed to pay the rest. She has never made a payment. I reached out to SOS. They tried to reach out to her. And it's my understanding that the rapid rehousing ends at the end of July. So in August, she's gonna be responsible for the whole thing herself. She hasn't filed a rental assistance form. I don't think it's a tribal issue. In fact, we would ask the court for a judgment.
All right, ma'am, what did you wish to say?
Now we finally hear the tenant side in detail. Job loss, transportation problems, depending on buses with children, waiting for assistance programs, offering partial payment. And this is where eviction cases become uncomfortable, because both realities can be true at once. A landlord may genuinely be owed money, while a tenant may genuinely be struggling. Housing court sits right in the collision point between legal obligation and human hardship. Notice she isn't denying the balance exists, she's arguing circumstances changed. That difference matters, because now the story shifts from "did this happen" to "should more time be given?" And judges have to make those calls constantly.
Anyway, like I was saying, SOS was paying my rent for 3 months without me having to pay anything. Like I told Ms. Terry through SOS that I ended up losing my job. And I wasn't able to pay nothing at the moment. And I'm just now getting a job. And I wasn't able to pay nothing until today. But yeah, and I sent in my SER through the mail. I didn't know I had to come and actually bring it here. I don't have a car. So anytime I go anywhere, I have to get on a bus with my children. So I don't know if you're able to, if they bring the mail to y'all, but I definitely sent the SER to this courtroom with the judge with your name on it, Cedric Simpson.
Did.
But SOS doesn't stop. She said that I already filled the paperwork out yesterday when she came. They pay August, but after August, I won't be getting no more help from SOS. But I reached out to Hawk. They're able to help, and I did do an SCR with my caseworker, and I have an appointment with my caseworker on Monday for help, so I can get help with my rent. And I'm able to pay altogether $900 today, but that's all I can afford.
Well, if we get to August 1st, then August rent is going to kick in, which means you're not going to be.
No, August rent is paid by her, by SOS.
I'm going to let you finish because I'm not going to be interrupted again.
I'm sorry.
So what else did you want to say?
That's all I had to say. That's what I said. It was already paid. August month is already paid. That's why she came over yesterday and I filled out the paperwork. So August month to be paid. After August, September, I won't be getting no help after August, is what I'm telling you.
If SOS pays in August what they paid in July, it would be $650 on a $1,300 apartment, which would mean she'd be responsible for the other $650.
That's not true.
But even without, let's assume that for the sake of argument that SOS is going to pay the whole thing. She still has a $4,200 balance. And I don't think there's any way that's going to be paid. And she hasn't filed the form, even though, you know, the previous person heard you just fine last week when you said, we get it here within 5 days. It wasn't here within 5 days. We'd ask for a judgment today.
I did turn it in within 5 days. You said turn it in Wednesday, which I did turn it in Wednesday. And who is he to say that I won't have all of it paid? Like, you don't know that. I didn't know I can get as much help as I did until I reached out to all these companies. And I was unemployed for a while, which I just got a job. I just started working 3 weeks ago. So this is my first check. You have to wait 2 weeks in a hole to even get your first check.
Pay attention, because the legal strategy changes here. The plaintiff isn't just saying money is owed anymore. He's saying there's no factual dispute left, meaning, from his perspective, judgment should happen now. That's important. Once a court believes facts are largely uncontested, arguments start narrowing. The tenant believes future assistance may solve the problem. The plaintiff focuses on existing debt. Two completely different timelines colliding, one about hope, one about current obligations. And courts often operate on what exists today, not what might happen tomorrow.
Your Honor, I'm willing to extend the judgment, normally be the 28th, if we were to extend the judgment to August 4th.
There's no tribal issue for this court.
This is the decision moment. Judgment for possession gets issued, but listen carefully because people misunderstand this phrase all the time. A judgment for possession doesn't always mean immediate removal. In this case, the judge appears to create a redemption window, time to pay and potentially avoid losing possession. That nuance matters. Also, notice something subtle. The judge intentionally avoids adding August rent into the amount. That could be interpreted as giving the tenant a cleaner path to catch up. So while the ruling favors the landlord legally, the structure suggests an effort to balance enforcement with opportunity.
In regard to this case, I'll grant a judgment for possession with the redemption amount of the $4,298.39 with a writ to issue August 4th, 2025. Thank you.
Can you tell me exactly what does that mean?
I just issued a judgment, the 429839 will need to be paid on or before August 4th of 2025. I've done it that way because if I grant an adjournment in this case, quite frankly, whatever the dispute is with the August rent would be added on to this figure, which I was trying to say earlier.
Yeah.
So it's a benefit that if you can find the funds to get this paid, you only have to pay this amount. Does not include anything for August.
Okay.
Right? So you have to the 4th to get it paid.
The hearing is basically over, but the tenant keeps trying to explain August assistance. And honestly, this final exchange might summarize the entire case. Two people talking about related issues, but not the exact same issue. The tenant is saying future help is coming. The judge is saying, I'm deciding based on the judgment before me right now. That disconnect happens constantly in court. By the end, the biggest lesson here may not be about eviction law at all. It's about timing, presentation, and communication. Because legal systems don't only evaluate hardship, they evaluate evidence, deadlines, procedure, and clarity. And sometimes people lose not because they had no argument, but because they couldn't deliver it in a way the system recognizes.
Yeah, but last thing I gotta say is that when I talked to my SOS worker, Miss Terry, our agreement was for her to pay the full amount because she know I'm not gonna be able to pay the full amount. The money that I have now is going to be towards to the money I already owe. So August is already gonna be paid. Like the full amount is gonna be paid, so I won't have to worry about August.
Maybe you're not hearing me.
I'm
I
hearing
just
what you
issued
said.
The judgment. I'm not dealing with August.
I know that. I'm just let you know for sure that's gonna be paid. That's all. But thank you. Have a nice one.
Thank you.
Jesus. People with roads.
Won't stop.
Nope, doesn't work.